Welcome to the Montana Department of Labor and Industry Employment Standards Division course on vacation and PTO policies. This video is intended for those in the private industry in Montana, meaning those employed by non-government entities. In this video, we will address the differences in vacation time and paid time off, PTO, when these differences apply and what is required by law. Before we begin, it may be beneficial to have access to your current employee handbook or policy manual in order to get the most out of this training. Private industry. There is no requirement under Montana state law for private employers to provide paid leave benefits to its employees. It is strongly suggested that, if offered, these benefits are defined and clarified through the employer's policies, usually outlined in an employment handbook. An employee policy or handbook typically provides direction on how these benefits are accrued or earned, when and how they may be used, and whether they are paid out upon termination. There may be a cap placed on the number of hours an employee is allowed to accrue, use, or carry over each accrual period. The Montana Department of Labor and Industry is only able to interpret the vacation and PTO policies as they are outlined in either practice or by the employee handbook or policy manual. Vacation. An Attorney General Opinion, Volume 23, Number 56, which is enforced as law, held that once vacation benefits have been earned and are usable in accordance with the employer's policy, they are due and payable as wages. Furthermore, a Montana Supreme Court decision, Langager v. Crazy Creek Products, Inc., also held that once the benefit is earned, an employer may not impose conditions afterwards that would take away what has already been earned. Essentially, Montana does not allow use it or lose it policies for earned vacation leave. Since there are no statutory requirements that vacation benefits be given to any employee in the private, non-government sector, the right to vacation benefits comes from the employment contract or agreement between the employer and employee. This is usually covered in the employee handbook or policy manual and should clarify how vacation time is accrued or earned. There is a distinction between accrued vacation time and earned vacation time. For example, some policies will allow an employee to earn a certain amount of leave according to their years of service, or perhaps the leave is front-loaded at the beginning of the year to be available for use. Most likely, these benefits actually accrued prior based upon the pay period, month, or based upon the hours worked, whereas other policies simply indicate vacation is earned on an anniversary or other significant or specific date. Additionally, some policies may allow accrual of vacation time during a probationary period. However, limits any use of the accrued time until the probation period has passed. As such, it is necessary to determine when the vacation time truly becomes earned in order to be used. Employers may also limit or cap the amount of vacation time that employees can accrue and/or earn in a specific time frame. However, once an employee earns vacation time according to the employer's policy, it is considered as wages and must be treated the same as all other regular wages. If an employee terminates for any reason, they must be paid for all earned and unused vacation leave in the same manner as their regular wages. Paid time off, PTO. Similar to vacation, PTO is not a requirement for a private industry, non-government employer in Montana to provide under state law. However, if it is provided, the policy or handbook should define how and when it is earned, usable, and paid upon termination. Paid time off may be offered by employers under a variety of names, as they can lump many different types of paid leave benefits under the PTO umbrella. These may include holidays, days taken for personal illness, bereavement leave, or other personal reasons such as taking a vacation. Generally, if the policy is a combination of leave benefits, it will most likely be considered as PTO for purposes of enforcement. Enforcement of PTO differs from vacation time due to a Montana Supreme Court decision, McConkey v. Flathead Electric Cooperative, which found that personal time does not automatically qualify as wages, and the employer may define whether the benefit is to be paid out upon termination. When the employer's policy indicates payment is to be made, there exists an obligation to pay PTO as wages. If no obligation is made, there is no requirement to pay out what has been earned and unused. Sick leave. While discussing leave benefits, it is important to note that while authority exists to enforce payment of vacation and PTO for the private sector, no such authority exists regarding sick leave benefits. If an employer has offered a benefit for time off with pay for illness, there is no obligation to pay out what has been accrued, earned, or unused upon termination. This concludes the presentation for vacation and PTO policies for private industry. Additional information may also be found on our website. Thank you.